All right, counsel is approaching. We have yet some more objections, one of which is sustained, and this is cross-examination, and defense is saying, no, it shouldn't have been sustained. So let me introduce now, we have a new special guest joining us as a legal analyst, criminal defense attorney, Roger P. Foley from Florida. Thanks again for joining us today.
Thank you. I appreciate it, Ashley.
Absolutely. So let's talk a little bit about trial skills. And what he's just asked this witness is, all right, I want to look at the total number of cars towed between January 09 and June of 10. There was a relevance objection that was sustained. Why would that be relative? If they're talking about this particular car being towed, who cares about how many were towed over that long period of time? Any guesses?
I agree. I think that he's really just looking at credibility of the witness to see his memory perhaps on this particular vehicle. So he's going to ask him about some other vehicles, because why would his attention be so focused on this vehicle versus the hundreds or dozens of other vehicles that he may have towed during that same time frame?
All right. And how would you attack his credibility? Because the thing that I note is he's testifying some about current procedures, right? Like if a car's there 2 hours after closing, we tow it. And then he's also testified in 2010, same policies. But then I felt like he wiggled a little bit and said in 2010, the security guard would determine whether or not a car should be towed if they thought that the person had left the property. So would you use any of that information in your experience as a criminal defense attorney to actually attack the credibility of this witness?
I don't think I'd spend the time, Ashley. I don't know that it's necessary for this witness. I mean, you need to choose your battles. The only reason I can understand even cross-examining in any detail this witness is to determine maybe how many times the tow truck company had passed through that parking lot, to determine how long the vehicle had been there. As far as impeaching his credibility, he has no reason to lie. There's really no reason to impeach him. Maybe he's made a mistake on time, but I don't think that the time is being spent the correct way at this point by counsel.
All right. And so let me ask you this. I'm going to pick your brain since I have your expertise here, because one of my other guests and I talked about this very fact. We are continuing to see a large number of objections. Frankly, a number of them are sustained. Some are overruled. What do you think this is doing to the jury, who is continuing to listen to the attorneys object, approaching the bench? How does that affect them listening to this case?
It's a mixed bag, Ashley, because they become frustrated with the attorney asking the questions, because he's not necessarily asking one fact questions, which is sort of the manuscript for doing a proper cross-examination. And they also get upset with the other person making the objections because, hey, let the man speak. Let us hear what we want to hear. So it's a mixed bag. It really depends on the individual juror, but it does disrupt the rhythm of the attorney that's asking the questions, especially when they're being sustained. You see him stopping and starting, and not really making ground.
And so, you know, I do sit as a judge in Atlanta, and the thing I have to say is frequently I see what you just said. Attorneys make objections in order to disrupt the flow of the attorney who's questioning. But in this case, given the number of objections that are being sustained, I feel like it's more of the attorney not really thinking about how to phrase his questions in the first place. What do you think?
I agree 100%, Ashley. So I said I was noticing on some of the cross-examination, just not going with one fact per question, not always even leading, just asking questions. They could be formed better. It's easy to Monday morning quarterback or sit in judgment, but I think defense needs a little bit of work in regards to the way they're phrasing the questions, so they can avoid these objections and get on with the points that are necessary for the defense to make.
How many trials have you had experience with, Roger, that or the prosecution rather, has estimated this is going to be a 6 to 8 month trial? To me, that seems like a long time.
Well, as we're watching this unfold, you're starting to see why. The tow truck driver is not going to bring a lot of information to the jury here. What can the tow truck driver talk about other than he received a call to look at a vehicle, to tow a vehicle, made a phone call? This is his testimony for direct should be maybe 10 minutes and cross-examination all of 5 minutes, and we should be moving on.
All right. Well, we're going to dip back into trial now and see what's happening. It looks like the judge is speaking. So I want to tell the viewers what's happening here. We've learned that the judge during the sidebar has then asked the witness clarifying questions, and now they're resuming the sidebar. So Roger, let me ask you, and I just want to go quickly before we have to take a break, why clarifying questions in your opinion by the judge?
Because no one knows where the questions are going to. So I can only assume that when the attorneys went sidebar, they proffered what they wanted to see, and the judge still had questions. So in an effort to speed up and clarify the situation so we don't sit there and have objection after objection after objection, I think the judge just took it into his own hands and said, hey, explain it to me, and now we'll decide which way what questions I'll allow you to ask.
Yeah, I think you're right. At this rate, this trial will last a very long time. So great trial to cover in California, a really horrible, brutal murder. We are going to take a break, and then we'll resume court live in the McStay family case. All right, and so I think based on the questions being asked, although some are still being sustained, the objections made, that they are trying to prove, defense is trying to poke holes and say, listen, whether or not it was towed, when it was towed, doesn't mean anything in terms of identifying what may have happened to the family based on what happened to their car. Roger, do you have any different theory or knowledge as to what maybe they're trying to do with this?
Not at all. I'm kind of sitting here wondering with you, what exactly are they getting to? And the only thing I can think of is the gap in time. How long could the vehicle have sat there in that parking lot, or did they actually, in fact, see someone walking away from it? And since we haven't heard any testimony about them seeing anyone walking away, I think they're just trying to show the policies and procedures for towing, and it's not helping or hurting either side. It's spending time.
Right, and ostensibly the employee who actually filled out the tow truck form for the tow truck to tow is going to have to testify if they're the ones that saw anything.
Correct. So, but I think that they just wanted to establish, and I believe is it the state now that's asking the questions?
I think right now it's the defense, but that begs the question. We're going to return to it to see who is questioning the witness right now. Let's jump back in. All right, remember that we are broadcasting here Eastern Standard Time. This trial is taking place in California. The judge just announced they'll be taking a recess until 1:30 for the Pacific Standard Time. Now, here's what's interesting is, in this case, and we're in day 4 of the trial, there seem to be a number of different reasons why they need to break, when they need to break. One of the attorneys was late this morning. It got started late. It was supposed to start at 12:30 Eastern Standard Time. It did start late. Now the judge just said, listen, I've got staff. This is a typical thing in terms of the logistics of running a courtroom. Let me bring you back in, Roger. So in your experience, when you're in court trying a criminal trial and you're defending your client, do you feel like you have a lot of say, so to speak, over the logistics and the timing of the breaks and when the court's going to recess? Or is that up to the court and you have to go with it?
That's up to the court, and you always have to go with it. You don't have a choice. Sometimes they'll take a break right in the middle of a cross-examination of a witness. Judges they pay attention, and they try to not do that, but it happens, and you got to go with the flow. So when, like you said, the logistics, someone shows up late, a witness is late, an attorney is late, you got to go with the flow, however the court decides to rule on it. And when you need a break, you need a break.
And in spite of the attorney's request, that trial is on break until 1:30 Eastern Standard Time. We are now going to switch gears. Again, we're covering 3 different trials live. Right now, we're going to return to New Jersey versus Jeremiah Monell. This is one in which he is accused of stabbing his wife, estranged wife, and killing her. Brutal, brutal, more than 40 stab wounds to this deceased. The 12-year-old son who testified earlier today witnessed that crime. He's now 14 years old. We're returning live to court where the forensic pathologist is currently testifying. All right, we've lost sound in that trial. Again, this is the Jeremiah Monell trial, and really a interesting case because you have an eyewitness to the crime, which, as we all know, often doesn't happen. He was 12 at the time of the crime. He's now 14. The defense in opening statement said, listen, you have the wrong person. Jeremiah didn't do it. Mr. Monell's not the one who killed his estranged wife. But we did hear testimony today from the now 14-year-old child who says, I saw him do it. Dad even looked at me and said, uh-oh, you shouldn't have seen this. And the son says, he killed my mother. I saw him stab my mother, and he hid under the covers and cried, perhaps because he was not just traumatized, but also because he might have been afraid of his father, who he just testified under oath in front of his father that he witnessed this crime. So let me ask Roger, our criminal defense attorney here, what do you do in a circumstance like that when, as a defense attorney, when you have an eyewitness who, quite frankly, appeared to be very credible on the stand, reliable? What he said now 2 years later was the same thing he said at the time of the murder, who's an eyewitness, and you come in and say, oh, I didn't do it. Do you think that defense is going to work?
Not at all. I think that the reason we're here is that the offer that the state gave Mr. Monell was 30 to life. So why not go to trial? Because he's basically looking at a life sentence either way. And based on the evidence in this case, it's very likely that he is going to be convicted of this crime. It's very difficult. A 12-year-old is on the stand, his own son saying, I saw my father do it. I mean, just the tragedy that the child, is witnessing a crime like this and being forced, in effect, to testify against his father, against, I guess it's his stepmother. It's just a terrible fact pattern.
And let me just interrupt you. We do have to go to a break. It's very traumatic to children. Always remember the victims in these cases. We'll be right back. I'm going to be your host for the next 2 hours. We have a lot to cover this afternoon. Let me just kind of take a couple things through with you. The McStay trial out of California, they are on a break. They will be back in a little while. We're also covering the New Jersey v. Monell case. They are also on a break, and we're going to be bringing that back live to you when they come back from their break. We're also covering the Melanie Iam case. This is another case in which we are on verdict watch. So what we're going to do now is we're going to take you back in the Melanie Iam case. We're going to listen to some testimony of Detective Sean Oliver of the Palm Beach County Sheriff's Office. Let's hear what he has to say, and then we're going to break it down.
Detective Oliver, based on your education, training, and experience, why didn't you provide Ms. Iam with an attorney?
The encounter with Ms. Iam was a non-custodial interview. And based on that, she wasn't under arrest. Based on my training, I did not believe that an attorney had to be present.
And that was the testimony of Detective Sean Oliver. I have Roger Foley here from West Palm, Florida. He's been sitting in, helping us out. He's a criminal defense attorney, I believe, out of there. How are you, Mr. Foley?
Very good. How are you today?
Good. And so we just heard some brief testimony from the detective regarding a statement that was made. What do you make of that?
I didn't hear that statement, Julie. The feed didn't come through.
So let me just fill you up. This testimony that was given by Detective Foley was the reasons why he didn't give her an attorney, even though she asked for one. So why don't we break it down for a second? I see you smiling because every defense attorney knows that the minute an individual asks for an attorney, the first thing a detective is supposed to do is stop speaking to that individual. Is there any explanation you can think of why a detective would continue speaking to someone regardless of that?
There was a motion to suppress on this case. This case is right down the street from me in the courthouse that I practice at. So I'm aware of what's going on. And there was a motion to suppress the statements made by her because she asked at least 3 times for an attorney, and the judge ruled against the defense in this argument. And I think it's a built-in appellate issue. And I think that based on her statements coming in of her involvement in what she basically confessed to, you're going to have a guilty verdict. But the issue is did the judge make the correct decision in allowing her testimony to come in, even though she asked for an attorney?
So are you familiar with what the judge's reasoning was as to why it was allowed in?
I am. I read his order, and the argument that he was that she was voluntarily there, that she was interviewed in her home or in her relative's home around a kitchen table, that she wasn't sitting in a jail cell, she wasn't handcuffed, allegedly she was free to leave. These are arguments, but again, we all know Miranda. If you ask for an attorney, you're allowed an attorney. But the judge in this case said that she consented, that she voluntarily gave statements. But the issue is, and the appellate issue is going to be, did the detective ask her questions to elicit a response? And if he asked something and she responded and she had already asked for an attorney, my belief, and I think thousands of defense attorneys across the country are saying, what's going on?
Got it. Look, I mean, this is New York. You know, the minute you say the word attorney or even we usually are able, the detectives usually shut it down at that point. At least we hope they do. We're going to go back into additional testimony. Let's take a look. And that was the testimony of Detective Sean Oliver on cross-examination. He's talking about the reasons that he didn't give Melanie Iam an attorney, and trying to explain under cross-examination that she was free to leave. I'm going to talk for a moment with Roger Foley, who happens to be practicing in Florida. You know, Roger, it sounds to me that we now have an individual who's in her home who is now basically, whether it's 1, 2, or 3, is surrounded. She's a little girl, if we look at her, surrounded by officers. Her vehicle's been towed, which means she can't leave even if she wanted to. And we know from the testimony of the officer, the detective himself, that she has asked for an attorney at least 3 separate times. How on earth is a jury or anyone supposed to buy that she voluntarily gave a statement beyond a reasonable doubt if all these things are in place? Did I answer your question for you?
No, it's just silly as you sit and listen to the detective testify, saying that she was free to go. There's police cars outside. She walks out. She can see them. They can see her. They remove her vehicle. Is she going to walk from Maryland to West Palm Beach? I mean, it's not right down the street. So if they had taken her driver's license, there's case law that says she's not free to go. I would think the next step, logically, if they take your car, where are you going to go? So I just find this officer to be hedging the truth a little bit.
Yeah, it's an excellent point. And, you know, one always wonders when a detective gets on the stand and you have a witness or a potential suspect who has asked for a lawyer once, twice, or 3 times, and the detective continues to question them. It goes to their credibility, but also starts to question how strong they believe their case is. If they believe they, in a sense, have to violate the potential suspect's rights in order to make a case against them.
Absolutely. It's the problem is the jury going to look at the misconduct or possibly alleged misconduct of the police officer versus, you know, what the statement of the defendant was, that she stabbed her boyfriend. And I think it's hard to get past it. You know, you never know what a jury's going to do, but are they going to say, hey, well, she didn't have a lawyer when she said it, or are they going to exclude it on their own? Because the court has already decided that it's coming in. Right. So what's a jury going to do? And you know, you have jury nullification, and it's a possibility in this case, but it's a balancing act, right? What's that jury going to say? Like, bad officer or murderer, right? That's the problem that the defendant and the defense is dealing with right now.
And hopefully we'll know soon enough if this verdict comes back soon. We're going to take a break, and we'll be right back. And you're listening to the passionate rebuttal closing argument of the prosecutor in the Melanie Iam case. And I want to bring in Roger Foley, who is our guest from Florida, coincidentally. And, you know, one of the things that obviously stands out about this case is that there was a mistrial. So the jury had heard all the evidence before and could not make a decision about the guilt of this young woman. And so, you know, we're now on a second round of trying this case. And in this case, Melanie didn't testify. And my question to you, which is a question I think that all of us as attorneys on both sides always ask, is who has the advantage usually when it comes to retrying a murder case? Is it the prosecution, is it the defense, or is it kind of a split?
I would say it's a split. You know, it depends on the facts of the case. In this situation, from what I'm seeing, that prosecutor was doing an outstanding job, was closing, was passionate, had her thoughts, you know, put together well. I think the jury's relating with the passion because the way she's describing, you know, the roommate and holding him in his arms and putting the glove on and taking the time to do that and show that the knife's just bent, that she's doing an outstanding job of presenting her case to the jury.
Sure, and I guess the question always is, you know, when we have a scorned woman, a scorned man, you know, the question is, we talk about nullification, or even a jury finding that she is guilty, but not guilty of the top count, but instead of maybe one of the lesser counts, kind of cutting her a break in terms of some level of a crime of passion. Do you see that here?
I do, because I don't think anyone's thinking that this young lady, you know, 19, 20 years old, went to her boyfriend's house. She didn't show up with a weapon. I mean, there happened to be a weapon, you know, there. They happened to be in the kitchen during this argument. So I think it's a definite possibility. I think you hit it right on the head.
Yeah, no, I want, you know, look, I mean, sometimes, you know, with the jury, you can't decide whether they can't make a decision because they don't believe someone's guilty or because they can't decide between the two. You know, it's always interesting when a defendant doesn't take the stand. Do you think that she made the right call by not testifying? Obviously, the jury has heard from her already because they've heard from her statements to the detective after she asked for a lawyer. But do you think that it would have benefited her in any way?
Not even a scintilla. Not a drop. It wouldn't have helped her. It only would hurt her and the prosecutors in Palm Beach. These two particular prosecutors trying this case are very good at what they do, and they would have crucified her. And best thing her defense attorney did this time was not put her on the stand.
I don't know them, but I couldn't agree more. We're going to take a break. I'm sorry, we're not going to take a break. We're going to go into the defense closing arguments on the Melanie Iam case. Let's take a look. Hello. And that is the closing argument of the defense attorney in the Melanie Iam case. Another passionate speech from the defense attorney. Roger Foley, I'm going to bring you in. You know, we talked about the passion of the prosecutor. I got to say, the defense attorney is doing a pretty darn good job of, you know, poking holes in their case. I'm not sure. There's a tendency for me to think that he's kind of trying to, I hate using the phrase, throwing everything on the wall and seeing if it sticks. I hate that phrase, but it seems like that might be what he's doing.
He is absolutely doing his best to make lemonade out of lemons. I mean, there's no doubt here. But how is the jury reacting? He's making some leaps. I mean, baggaging up the close of, yes, they should have done that, but we have a statement. She made a statement. You only have the cards you're dealt, and he was dealt a very difficult case, and he is earning every dollar. I don't know if he's a assigned attorney or if he's privately retained, but he's earning his fee today. He's working.
Yeah, it seems as though one of the things he's focused on, obviously, besides the fact that the statement was made, you know, without Miranda and with her asking for a lawyer, is he's focused on the lack of investigation and saying, you know, why didn't they put their gloves on? Why didn't they take these items? You know, basically putting it on the prosecution for their failures to do their job, and therefore somehow you should find her not guilty. I guess the question at the end of the day, and this is kind of what we were talking about before, is, you know, when you have a jury that you think is going to find someone guilty, are you better off saying, my client didn't do it, or my client did it, but here's a reason, and give her some kind of level down?
No, I think as a defense attorney, she didn't do it. Innocent. It's their burden to prove it, and you're going to make them prove every single aspect. And it just shows the level of commitment that the defense attorney has taken on this case to not just attack the Miranda. He has a very good argument for the Miranda, and it wasn't granted. So he is taking apart each, piece by piece. We always make the analogy, cutting the limbs off of a tree to make it less of a battle, so that tree doesn't fall. You can cut that by taking it.
Okay, I think I lost a little bit of a feed. We're going to take a break, and we'll be right back. Live in the New Jersey v. Monell trial. We're about to cross-examine one of the witnesses who is testifying in regards to events that occurred prior to the death of Tara O'Shea Watson. As many of you know, the main witness is the defendant's son, who was 12 years old at the time that he observed his father brutally murder his mother. And so it looks like there's a sidebar coming up. Let's take a look at what's happening. Sorry, I apologize. If I can bring you in, Roger. Foley is a criminal defense attorney out of Florida. The testimony we've heard right now is from a witness. She's about to be cross-examined. She wasn't on the stand very long, but she's talking about kind of the defendant, his demeanor when it came to the victim in this case. Obviously, the jury has heard from probably the most telling witness that anyone can imagine, which is the child who saw the vicious murder. Do they need anything else? And I hate to look. I was a prosecutor for too long to admit. But if I'm a prosecutor, I'm pretty confident I have this one in the bag after this young man testifies.
I absolutely agree. But their job is to put all the evidence in front, because you never know how a juror is going to look at it. A juror may have a question about, does he normally act this way, or was this an isolated incident? So giving this background does help the jurors understand, and obviously there are motions in limine to determine whether or not any of this evidence outside of this particular incident this night was going to come in. So they've already had motions on that, and obviously the judge is allowing it. So they're going to talk about this man and his demeanor and his reputation in the community and what they saw and how he acted. So they don't need it, but they're doing their job. Yeah,
and where does the defense go with this case? I know, look, we're hearing case after case, and I think you said before with the Iam case, you deal with what you're dealt with. You kind of have to, your defense attorney, you have to fight regardless of what is against you. And I think that we have to say, I think even in this case, I think even stronger than the case we just talked about is, what does a defense attorney do besides, you can't lay down. And so the question is, perhaps you should have pled guilty, but where do you go?
Here's what happens. In this case, Monell was offered a 30-year to life sentence. Right? So what is he going to do? He has nothing to lose. So he told his attorney, I want to go to trial. And so now what the attorney's doing is making the best arguments he can make. He's sharpening his skills, because this is a lose, lose, lose case. But the defense attorney is going to make the most of it. He's going to train himself. He's going to be better. He's going to give his best efforts. So when he has that innocent person, that he can actually make an argument, he's sharpened his blade and he's ready, and there's no pun intended on the sharpening the blade.
You could say that on multiple cases that we're dealing with today. We're going to go back into the Melanie Iam case. The jury has asked for several things, including the statement that the defendant made to the detective. Let's go back into the courtroom there. Welcome back. We're presently in the Melanie Iam trial. The jury has asked for some readback, specifically the testimony or the statements made by Melanie Iam to Detective Sean Oliver. Before we go back into the courtroom, I want to first thank Roger Foley. He's been in with Law&Crime for a couple hours now, helping myself out, and Ashley Wilcott. Roger, thank you so much for being here, and we would love to have you back.
Thank you so much.
And now let's get back into the Melanie Iam courtroom, and we're listening to, again, the statements by Melanie Iam regarding the day her boyfriend died.